Good morning. During a declared emergency in the City of Toronto, Committee of Adjustment virtual public hearings are being conducted by electronic means through WebEx, an online digital platform, and streamed on the Toronto City Planning YouTube channel. These measures are necessary to comply with physical distancing requirements and a provincial order that limits attendance at public gatherings. This will be a virtual public hearing, and participants who have registered in advance will be able to make the presentations to the committee using WebEx, an online event that is being moderated by city staff. Anyone wishing to view the hearing may do so by watching on YouTube. Participants who have registered in advance will be connecting either by their computer, a phone or tablet app, or by telephone. All participants will automatically be muted on entry. When your item is called, each participant will be unmuted by the moderator, one person at a time. Only the committee members will be participating by video. Any registered participants will be participating by audio only. We ask that you also mute your devices until you are called on to speak. We acknowledge the land we are meeting on is the traditional territory of many nations, including the Mississaugas of the Credit, the Anishinaabe, the Chippewa, the Haudenosaunee, and the Wendat peoples, and is now home to many diverse First Nations, Inuit, and Métis peoples. We also acknowledge that Toronto is covered by Treaty 13 with the Mississaugas of the Credit. In accordance with sections 45 and 53 of the Planning Act, this meeting of the Committee of Adjustment of the City of Toronto is called to order. The Committee of Adjustment considers applications for variances from the provisions of the zoning bylaw that applies to property, permission to extend or alter lawful non-conforming uses, and consent to sever property to create new lots. Anyone in attendance today who wants to receive a copy of the decision on an application must submit a written request for a decision by email. Please ensure you include your name, address, and email address, because Committee of Adjustment and the TLAB will be sending notifications and appeal updates by email. If you do not agree with our decision, it may be appealed to the Toronto Local Appeal Body, TLAB, or in some limited circumstances, to the Ontario Land Tribunal. Appeal instructions are set out at the bottom of the decision of the committee. Today, I will call each item in the order listed on the agenda. Where an application is uncontested, the agent or applicant will proceed with their presentation if required. The committee may ask questions and/or take the matter into committee for a decision. Each speaker, including the applicant agent, will be given a maximum of 5 minutes to address the committee. I will comment when you are reaching the 5 minutes. When addressing the committee, please state your name and address and confine your remarks to the matters outlined in the application. The applicant or agent will present the application to the committee first. Please note, the committee may not entertain revisions to proposals at the hearing today. If the application is substantially revised, the committee may decide to defer it to ensure the revised application is accurate and all those entitled to notice of the application are informed of the changes. Then, individuals in support of or opposed to the application will be invited to speak. Committee members may ask questions of each speaker after they have finished their presentation. When all other speakers are finished, the applicant agent has an opportunity to rebut issues raised by the speakers. This will mark the end of the discussion. The application will then be taken into committee for a decision. We have a motion for confirmation of the minutes of the last meeting. Yim? Joanne, you second the motion? All in favor? Thank you. Are there any declarations of interest of panel or staff or items in the morning time slot? Yes, Joanne?
I have a declaration on item number 4. A friend has made a written submission on that application.
Right. Okay. Any others? None? Okay. Madam Deputy Secretary Treasurer, have you received any requests for a deferral?
Good morning, Mr. Chair and panel members. We could deal with item 15161 Lisker Street at this time. There was improper notification, which is an automatic deferral, and the file has been scheduled for the October 27th hearing.
Number 15?
That is item 15161 Lisker Street.
Okay. Is there anybody here on that, or is it sort of, we're gonna do it automatically, or make a motion?
We do have the agent on the line as well as one of the residents.
Okay. Mr. D'Oliveira?
Just give me 1 second. I'm gonna try to, the agent is not online, so I'm just gonna try to call him.
Not able to reach him?
We actually don't have his phone number, so I just sent him an email. I'm just.
So maybe we'll hold it down until
Okay.
either he shows up or we reach it.
Okay.
Are there any other deferrals?
Not at this time.
Okay. So, are there any files to be closed?
None to be closed.
Thank you. Let us now go back to number 1. So, could you help me? I don't have a list here. That's why I'm struggling to get back to number 1, but otherwise I could have just hit it on the list. So I don't have my list displayed. Yeah, it should be here. Should be it.
Oh.
I do it all the time, but I never remember. Okay, number 1, 34 Sullivan Street. The purpose of this application is to legalize and maintain a 5th dwelling unit located in the basement of the existing 4-unit, 2.5-story semi-detached dwelling. The existing parking space within the detached garage will be maintained. With this application, we have material submitted by the applicant, email correspondence from transportation. Mr. Treen?
Yes, I'm here.
Okay. I don't think we need a presentation from you. The panel might have some questions. Panel, do we need a presentation on this application? No? Okay. Do you have any questions? Okay, I have a question, Mr. Treen. The variance number 1, is the secondary suites aren't to take up more than 45% of the dwelling unit, and we recognize that that isn't always possible when you have more than one secondary suite, but I don't think we've ever seen one for 236.5% of the interior floor area will be secondary suites.
Yes, I mean, the house has been carved up this way for many years now. The owner maintained one suite, and then the others, been rented out. Anyway, so he's looking to kind of, at one point, the basement was separated out into 2 units, and he's looking to legalize that situation.
Okay, so was there some consideration at planning to designate this as an apartment building?
It wasn't something that was great. I mean, we submitted the drawings for the, preliminary zoning review and state prints. I mean, the parking was the one issue, and then the other issue was the ratio between, primary suite and secondary suite. So that's as far as it went.
Okay, all right, panel, do you have any questions? Okay, do we have any discussion? Do we have a motion? Yes, Joanne?
I'd like to move a motion, to approve the application. There's no change to the exterior footprint, units in existence. Secondary units or multiple secondary units are not uncommon in this area, and I would move to approve the application.
We have a seconder? I can't see. Larry? Yeah, okay. Okay. All right, all in favor? You have your approval, sir, thank you. Number 2, 91 Berkshire Street, 91 Berkshire Avenue. Purpose of this application is to construct a new 3-story detached dwelling with a new front porch and a rear detached garage with a carport. With this application, we have material submitted by the applicant, email correspondence from Toronto and Region Conservation Authority, and a report from Urban Forestry. Mr. Berry. All right, could we have for the record, could we have your name and address, please?
Yes, Mr. Chairman, Dan Barry, 39 Victoria Street, Unit 1000.
Okay, can we have your presentation? We have some opposition, and there's a lot of variances here.
Yes, through you, Mr. Chairman. Some clarification very quickly. This is being described as a new 3-story home. I just want to point
Any questions, panel? Okay, so let us move on to the Wendy Tay.
Wendy, you've been unmuted if you want to speak.
Yes, I'm here. We are about 2 doors down. We're at 86 Rushbrook. There's no real concern at this time.
All right, thank you. Go ahead, I'm sorry.
Right, there's no real concern at this time. I'm just a little bit, more, because for us, we are the, 86, you can see Rushbrook on the other side. It's more of the back setting of the garage in terms of how much it might encroach on the actual, Rushbrook laneway. I'm not sure, I mean, it seemed like they are, because right now existing, there is no garage, and it seemed like it is gonna come out quite a bit, so that's my only kind of concern and question in terms of how that's gonna look.
Okay, is that your only concern?
At this time, I mean, everything else, it doesn't affect me as a resident that much, because like I said, for us, it's the back laneway, you know.
Okay,
in terms
let's
of
go,
the-
let's,
That's why that's the case, but that's another matter.
all right, so we'll put this matter to Mr. Barry. Mr. Barry, will you address Ms. Tay's concern about the garage?
Yes, through you, Mr. Chair, I confirm that the front wall of our garage is set back 1 meter from the laneway edge. So, on this laneway, there are several garages that are actually abutting the laneway itself. We're set back 1 meter from the laneway and 0.54 meters from the actual rear setback.
Okay. All right, panel, do you have any questions? Yes, Larry?
Yeah, thanks, Eric. Just a quick one, about the 3rd-story balcony. This is a fairly tight, housing fabric for this street, and, I'm just wondering, I couldn't tell whether the proposal was for any screening on that 3rd-floor balcony or not.
Yes, through you, Mr. Chair. On the drawings, you are correct. There is not identified any screening, sorry, forgive me. No screening at the front. On the side walls that would be overlooking, let's see, so right now, you're screening, that's the front balcony. Yep. So on the front balcony, there was no proposed screening on the sides. There was on the rear. On the side is right here, privacy screening. And I thought you were referencing the back balcony. But the front balcony is not showing, but we would entertain that as a concern on the provide privacy screening.
Yeah, I'm not, frankly, I'm not talking too much about the front one, particularly it's off of the bedroom, right?
That is correct.
Yeah, so, I'm not too fussed with that one. Thank you for confirming on the rear, the one I was mostly concerned about.
All right. All right, any further questions? Yes, Joanne?
I'd just like to, with respect to the height, is there any other homes, that, have similar heights or are 3 stories? I know there's an apartment building at the corner, but any other houses, I didn't see any 3 stories, I just wondered if I missed that.
That's right, Mr. Chair. There are other 3 stories on the street, one number
Yes, Jim?
Yes, my question goes back to the garage, the setback at the garage. You're telling me that there's some garages actually way on the laneway. From the area, or at least from the information we have, I do not see that. That's one question. Secondly, the second question is, you said that 5.5 floor. So what is the like, it's still, it will give you 2.5 from the center of the lane when you set back, with the current setback that you're proposing, is that right? So it still give you the 2.5 from the center of the lane. Yes, that's what.
Yes, Mr. Chair, that is correct. So our rear yard setback request of 0.5 meters will still maintain 2.5 meter setback from the center of the lane. Okay, and with regards to your comment about garages being on the laneway, I should clarify, because what I really mean there is there are some garage doors that are located on the near of the lot line. So nobody's actually going to be out there lot line on the laneway, but near a lot line.
Okay, yeah, that's why, okay, thank you for the clarification, and I understand, and I understand why you asked for 0.54 now, that's 2.5 from the center. Okay, thank you.
Any further questions? Any comments? Do we have a motion? Yes, Larry?
Sure, I'll start off. I did know that there were some three-story along that street. They were in the third story, the mapping was towards the rear, so this would be the first one where there'd be a full frontage, three-story. Having said that, this is now becoming a fairly common design for many neighborhoods. This is close to Queen Street, it's close to the transportation. I think the variances overall are fairly minor, and I think I can support this one. If my colleagues don't have any comments to the contrary, I'm happy to move the motion to approve this application, subject to forestry number 2 and 3.
I see, Larry, that there's a TRCA permit required. Is that the condition we need?
Yeah, I didn't know whether we needed a condition on that, Chair. I'm happy to put one in, that if they need a TRCA permit, that they should secure one. I just didn't know whether that was a condition or it was just an acknowledgement from TRCA that has to be done.
Well, I don't know. But it won't hurt to put it in.
Sure, I'm happy to include that in the condition. I'm sure the owner and agent wouldn't have any difficulty with that.
All right. Seconder? Yes, Yim. All in favor? You have your approval, sir. Thank you.
This application has been approved unanimously.
Number 3, 2. 2 Halton Street, and the purpose of this application is to convert the existing 2-story, 2-unit detached dwelling into a 2-story, 3-unit detached dwelling by creating a new secondary suite within the existing building. With this application, we have material submitted by the applicant. We have correspondence from Permit Parking. We have correspondence in support from 1026 and 1028 Shaw Street, in opposition from 6 Hallam Street. Cayman Kostadinov.
Good morning, Mr. Chair and members. I'm the owner of 2 Halton Street. Yeah.
Okay, sir, I mean, you're not asking for very much, so I don't think we need a presentation. Panel, do you have any questions?
No, really.
Okay, so Can we have a motion or comments?
I have a motion.
Yes, Yim?
Any comments?
Go ahead,
Yeah,
Yim.
I have a motion to approve with no conditions, and I think that it's asking for one conditions. I assume in this area, it's about certified conditions. I'm okay with move forward.
Yeah, Joanne, are you seconding the motion? Okay. All in favor? Have your approval, sir. Thank you. Number 4, 54 Arundel. And the purpose of this application to alter the existing one-story detached garage located in the rear of the existing two-story detached dwelling by constructing a second-story addition. With this application, we have material submitted by the applicant, reports from community planning and urban forestry, form letter in support from 52 Arundel, and opposition from 58 Arundel. Mr. Ho.
Speaking.
Yes.
Morning, Mr. Chairman and members.
Can we have your address, sir?
My address is 222 Coxwell Avenue,
Right.
Toronto, Ontario. M4L 3B2.
Okay. So I don't think we need a presentation panel. Does anybody need Larry?
Thanks, sir. Just a point of clarification. I was looking at the site, and maybe I'm confused, but I noticed the description talks about it being a garage in behind a detached dwelling. I looked at it, looked like it was a semi-detached. Not a big deal, but I just want to confirm whether in fact it's detached or a semi-detached home on Arundel.
In fact, the main structure is a row house. It's the end of like a 3-building row house.
So the description that we have before us is incorrect, I guess. It says
Oh.
two-story detached dwelling.
Yeah.
Oh, okay, yeah, it must have been. Sorry, it's meant to be a row house.
Okay, so we should amend that. Thank you, Larry. Any other questions? Any comments?
I do, in discussion, I could have a comment. In discussion,
Go.
or you may have want to speak.
Go ahead, Yim.
Okay, my comment is this, the planning commissions have requested variance number 4 now to set back 2.5 on Center Lane. And I think it's a bit request because they suggesting to add 2.03, and also the second floor is still over into the lane. And if
Mr. Ho, can you address variance number 4, please?
Yes, my client, I have discussed with the client when the transportation department brought up I guess the encroachment into the clearance, and the client's prepared to cut back the setback if
Okay, so am I correct that this is an existing condition?
No, the existing face of the garage is 2.6 meters from the center of the lane. The second floor, we had proposed a cantilever to protect the new garage opening, but we are happy to cut back on the cantilever in order to meet the 2.5 setback from the center of the lane cost.
Okay, so can we eliminate variance number 4?
Yes.
Okay, yes, Larry?
Thank you. I'm gonna throw a little bit of a wrench into this one, and I appreciate both of your comments on this. I'm concerned about the height variance, frankly. I'm fine with garages which exceed or auxiliary structures which exceed the height requirement when those height increases are supporting a broader municipal or provincial interest. In this case, laneway streets are something that adds accommodation to laneway height type or rear structures. And in my view, the added height is offset by the community benefit of having additional residential in the rear structure. I'm not a big fan of proposals which seek to exceed the height bylaw when there isn't any real added benefit to the neighborhood or the community. And I think that's the case in this situation where a large structure is going in behind. There isn't any additional rental accommodation which would benefit the neighborhood. And there is an opposer who shares some concerns about that. And I'm a little uncomfortable with these kinds of applications for height additions in the rear dwelling when there isn't an offsetting benefit to the neighborhood or the community at large. So I'm a little bit uncomfortable with the height in request in this situation.
Mr. Ho, could you address that issue?
Yes, so the homeowner, Jonathan and Christian, with their adopted son, they had an assessment done on their main structure, the row house, a few years back because the family is growing and they needed space. And in doing the assessment by a structural engineer, it was very difficult and cost prohibitive for them to have any additional space added on the main house. So they
Mr. Ho, could you give us some details as to what use your client intends to make of the second floor?
They intend to use the second floor as a little bit of like a home office space because the homeowner, one of them is an educator, the other one is a nurse, so they do work from home from time to time, and their child, Liam, who also during COVID was spending a lot of time at home, they just need extra space to kind of spread out and be able to take calls and engage with the work in the space, and then they also want to have a space for arts and crafts, that kind of thing.
Okay, panel, do you have any further questions? Yes, Yim?
Yeah, the question is, I think initially, that's why the variance revised, you were actually trying to apply for Lakeway House, and it's been changed. The reason is because it's economic or only because the current situation does not meet the Lakeway requirement.
So, in my discussion with committee, community planning, they said the Lakeway Housing Act is stipulated on the connection of sanitary provisions through the main house. And the main difference between our application to a typical laneway house is that the owner is not looking for any plumbing provisions in the space. They don't intend to use it as a sleep accommodation or like a dwelling accommodation. They just want a day use space. So this is being considered as just a standoff application as opposed to a laneway housing application.
Okay, thank you.
Thank you.
Okay, any further questions, or do we have comments or a motion?
Through you, Mr. Chair, could we just go through the variances to ensure that we have it correct?
Right. Okay, Mr. Ho, I'm gonna go through the variances just to check with you to be sure it's all correct. Variance number 1 is deleted. Variance number 1 is deleted? Okay. Variance number 2, you're asking for a height increase to 5.22 meters.
Yes, that's correct.
3, you're asking for 2 stories as opposed to 1.
That's correct.
4 is deleted.
That's correct.
All right, 5 is, 5 is deleted. No, just a minute, I got it wrong. 4 is, you're asking for a total floor area of 59.55 square meters. That's not deleted.
Yeah, that's correct. That's to maintain, sorry.
Okay, and so it's number,
I'm sorry. You said that the floor area will be smaller, isn't it?
Yes, that will be smaller as a result of the deletion of the cantilever outside.
yeah, okay, so I don't know what the numbers are actually. That was originally 5, it looks like it's 4 now. So the one about the 2.5 meter, which is, you're deleting that, correct?
Yes, that's correct.
Okay, and the last variance is rear lot line setback will be 0.26 meters.
Yes, that's following the existing footprint of the garage.
Okay, all right, thank you. Do we need any more clarification? No. Okay, thank you.
Yes.
Panel, any further questions? Yes, Yim?
And you still need a figure for the revised area of the auxiliary building, which,
Yeah.
yeah, is
Yeah.
59.55. We need to have another, the new number.
variance number 3 is amended from 59.55 square meters to 56.8 square meters.
That's correct.
Okay, thank you. Our panel,
Thank you.
yes, Jim?
I have another question, Mr. Chairman.
Yes.
Because my board is concerned about the height and then the applicant said that they need extra space. I just wonder how big is the floor area of existing house right now? Is it, they have 3 people there.
Yes, that's correct.
You know how big the house is?
The total square footage?
Yeah. Just
Uh,
about.
I don't have an exact figure, but it's somewhere around 900 square feet.
That's the whole, including the basement and everything.
The basement's only a crawl space, it's not
It's a
a,
closed space, I see.
yeah,
I understand. Okay.
thank you.
Okay. Do you have any comments, or do we have a motion?
We can have a discussion, because I do understand what Larry is thinking, but I, for his comments, very bad, because the laneway house bylaw, although this is not laneway, but it's also considered auxiliary building bylaw that is very restricted just to have some sites that will meet this requirement and will not create negative impact in the neighborhood. I understand that, but in this case, if you were to reduce the height variance, it's almost impossible to put four-meter height, right? So it's almost like a whole application is not possible. What do you think? The height is the cause of safety.
Yeah, for me, and I totally get that. I'm very sympathetic to the homeowner, and I appreciate their need for space, and they're, seemingly, it's very difficult for them to add on a house. I'm taking a bit of a broader view on this one. And again, if we are going to support ancillary structures in the rear of homes, where all other properties can see it, it just seems to me that there has to be an offsetting benefit to the neighborhood or the community at large through the provision of additional rental accommodation. So that's just my view. I, again, very sympathetic. I appreciate the need for space. But when we see the height bylaw in rear yard, without kind of an offsetting, reason for the neighborhood to support it, I find myself in a tough spot, supporting it, that's all. I mean, I get the, all the very good arguments the applicant is making, but I'm looking at this a little bit more broadly rather than with individual properties.
And Larry, I actually have the same idea is about the planning the intent of the bylaw of auxiliary buildings. It's a much broader intention. And I think that if by allowing 6-foot height for auxiliary building, then it's almost setting up a subcategory laneway house, which they do not meet the laneway house requirement, and they still can add extra living space, and I find that that's a contrary to the official plan, the intent of the bylaw. We're creating a subcategory, right, which is not like full living house, but still living space. And there are other ways to increase living space, I think, but then they think that it's economically feasible, economically paying.
Yeah. It's a tough spot, I get that. But, I appreciate Don's perspective on this one as well, but I'm kind of leaning towards not supporting it for that reason.
All right, so I have 2 comments. First of all, I understand that if the ancillary building was a little further from the house than it is, it could be 6 meters high. And the second thing is that I think when looking at it in a broader aspect, I don't think we should look at it to just benefit the neighborhood. I think you have to include the owner as well. And I think that this is a creative use of this space, not going as far as a laneway house because it was too expensive and they didn't really need overnight space, but they do need some daytime space. They have a 900 square meter house, which would likely be expensive to add on, etc. And this seems to me to be a creative solution. Yes, it's a sort of halfway between a one-story garage and a laneway house, but it allows his family to stay in this neighborhood. So I think that it serves a purpose, not only for these people, but for the neighborhood, and perhaps, I don't want to say it sets a precedent, but it is a creative solution, I think, for adding some additional space without going to the expense of actually creating a laneway house, which they don't need or want. So I would, yeah.
Sorry, John,
Go ahead,
that's
Larry.
Very helpful. The point you made at the beginning is a good one, and I just want to confirm that. You said, and you'll forgive me for my lack of knowledge of this, but you said if the house or if the ancillary structure were deeper in the lot, that they could, as of right, build to 6 meter height? Is that what I heard you say?
Yes, that's my understanding. I'm not sure, I'm not 100% sure I'm correct, but that's my understanding. Yes, Yim?
I think that it depends whether that house you're applying for laneway house. Yes, the laneway house, the minimum setback is 7.5 from the main house. You can have it at 6 meter height. But if you only applying for auxiliary building, I think it's still we have to comply with the auxiliary building height, which is 4. That's my understanding.
Yeah, you may be right, Yim.
Yeah, but I get sympathetic with your argument about the second point. I heard that many people have property that allows laneway house construction, but many homeowners find it extraordinary cost because it's really very difficult to construct in confined space. And square footage, dollar per square footage is quite
have a note that somebody was opposing it and they wanted privacy window film.
What is the privacy window? The false glass?
They wanted some film on the window so that there wouldn't be overlook on somebody else's property. I'm not sure which window they were talking about. Maybe Mr. Ho knows.
Okay. You cannot.
Yeah, I'm sorry.
Yeah, Miss,
Sorry. The homeowner at 58 Arrondo had contacted me, and their concern was the windows towards the east end of the building, which overlooks the backyard, may or may not have sight line into their backyard should the proposed development happen. So he had asked me if we're willing to submit an amendment into the committee to add window dressings or window treatment at their request. Should this become a concern, we had agreed to the amendment, and I emailed the committee of adjustment technician, but he had since told me this is not a condition that would form part of the amendment. This will be would technically be a private agreement between the homeowners.
well, I'm not so sure about that because we talk about privacy screening. I don't know why we can't talk about some treatment on the window to ensure privacy of the neighbor.
Sure. And my client's more than amenable to add window dressing to alleviate any privacy concerns. They are absolutely willing. When I initially notified that we're willing to make the amendment, the technician had informed me that's not typically a condition they added on, but I'm here on the record saying we are happy to do so.
Okay. So, Yim, did you want to add that to your motion?
I agree with the technician, because privacy screen is very different, it's outside the window, and then it's very difficult to regulate. Besides, people usually with the window, they have blinds, right? So you cannot regulate to say glass has to be always down. I think that I will leave just in the good faith of both neighbors to work this out. That's what I will.
Okay. All right. Joanne, are you still with us?
He declared a conflict, I think.
Oh, pardon me. Right. Okay, Larry, do you, are you second this motion? You do. Okay. All in favor? You have your approval, sir. Thank you. Number 5, can we contact Joanne and get her back? Ah, there you are. Okay. Number 5. "42 Merritt Road. Purpose of this application is to alter the existing 2-story detached dwelling by constructing a front porch enclosure. Pardon me, I skipped number 5, which is 77 Hawken. I think we should go back. Okay, 77 Hawken is number 5. And the purpose of this application is to convert the existing 1-story rear detached garage located at the rear of the existing 2-story detached dwelling into a rear 2-story laneway suite by constructing a partial 2-story addition. With this application, we have material submitted by the applicant. We have email correspondence from Transportation Services, a report from Urban Forestry, and support, a 13-signature petition in support. Mr. Leon?
Hi, yes.
I'm sorry, I almost skipped you.
That's okay.
Yeah. Okay, so, panel, do we need a presentation in this matter? No, no. Does anybody, so, Mr. Leon, do you have something to say before I take it into committee?
No, I think we covered most of it within our cover letter. The variances are really coming from retaining the existing structure and giving it new use. And so we have tried to keep everything quite minimal. And the new footprint is only an additional 9 square meters, but that allows for making it a two-bedroom laneway house instead of just a 1-bedroom.
Okay, just one question with respect to variance number 3. Is the 2.47 meter setback, is that existing condition?
That is an existing condition, yes.
Okay, thank you. Panel, do you have any further questions? Okay. We have comments, or do we have a motion? Larry?
Yeah, I'll start off. I thought this was actually a really good design. You can see the second story setback and sort of minimizes visual impact. I thought the actual variances being proposed were quite minor. They're existing conditions over an existing garage. It's in an area that I think can accommodate the plan and structure, so I'm happy to move approval. Joanne, did you have any? Good? Okay. Happy to move approval, subject to 4 conditions number 1 and 2, and I think the standard engineering conditions, so I didn't see, unless it was in the stuff, anything about the engineering conditions, standard, municipal address and such.
Yeah, I think that as engineer, we should always have the standard
Yeah.
because the fire safety and all that, they have to check that.
Yeah, I didn't see anything in the materials that I looked at, so.
I don't think it was there, Larry. I didn't have a note of it, but you're right, they're the usual conditions, we should include them. Okay, so do we have a seconder? Joanne, all in favor? Have your approval, sir. Thank you. All right. Now we get to number 6, 42 Merritt Road. Purpose of this application is to alter the existing 2-story detached dwelling by constructing a front porch enclosure. With this application, you have material submitted by the applicant, a report from planning, and 2 form letters in support. Mr. Smith.
Good morning, Mr. Chair. Jay Smith, 2814 Halton Crescent, Mississauga.
Okay, I don't think, Mr. Smith, we need a presentation on this matter. Do you have anything to say before I take it into committee?
No, thank you, Mr. Chair.
All right, thank you. Committee, any questions or comments, or do we have a motion? Joanne?
Thank you, Mr. Chair. I think this is indeed a minor change. Just want to close the front porch. The stair width is minimal. The landscaping is an existing condition. If my colleagues have no further comments, I would move to approve the application subject to the planning condition, tying it to plans.
All right, thank you. Seconder? Yim? All in favor? You have your approval, sir. Thank you. Number 7, 25 Elm Street. And the purpose of this application is to alter the existing apartment building by converting 3 parking spaces in the underground garage to accessible parking spaces. With this application, we have material submitted by the applicant, correspondence from Transportation Services. Mr. Kang? Mr. Kang, are you there?
Yep.
Yep, okay. Could we have your name and address for the record?
Yeah, this is James Kang. Basically, this is the 25 Elm Street. It's in Toronto. It's a residential apartments.
Right. I don't think we
Yeah.
need, I don't think we need a presentation, but I want to ask, the purpose is to convert 3 parking spaces to accessible parking spaces, and yet the variance reduces the number of parking spaces. I don't see anything about accessible here, so how does the variance fit with the purpose?
Well, apparently there's 2 existing bare-free parking spaces in the first underground parking lot. This 25 Elm Street residential apartments.
Yes.
So basically, we're adding 1 more bare-free parking spaces in here to have 3 bare-free parking spaces, and this is our Toronto Community Housing client's request of it. So technically, there was existing 2 bare-free parking spaces if you're looking at our plans, Mr. Chairman.
Yeah. I'm not quite sure I understand how the
So, Mr.
purpose.
Chair, I have a question further to yours. So are you saying that to create the, additional accessible parking spaces, you have to lose 9 parking
No.
spaces, 3 resident and 6 visitors?
No, basically, we are gonna have 1 bare-free parking spaces, and to do that, we have to lose 2 regular parking spaces only.
Okay, so to further to the chair's question, then you're going from 50 to 47. So are you saying that 2 of those accessible spaces were counted in the original 50 and shouldn't have been?
Exactly. We're just basically relocating those 2 existing bare-free parking to the nearest vestibule entrance, so it's much easier for the tenants to come into the vestibule, which leads to the elevator, much closer than the.
But that requires the removal of all visitor parking?
Yes. Well, just the accessible.
Can I interject? I think what the confusion is that the bylaws listing the minimum required, but we do not know the existing. Maybe the existing is already under the required. I do not think they are eliminate 9 spaces. I think that maybe the existing number is already efficient anyway. This is converting 3 in.
Yes.
Yeah, I think if you restrain it that way, probably it would be
Yeah. Okay. All right. Do we have any further questions? Okay. Yim, Larry, did you want to make a motion or comment?
I'm ready to make a motion, if there aren't any comments from my friends, for approval, and because there's no comment from transportation, they're okay with that. There's no conditions.
Okay. Go ahead, Yim. So-
Yes, I move approval, sir.
Okay. Joanne, you second that motion? All in favor? You have your approval, sir. Thank you.
Mr. Chair, we do have the agent for item 15 and the registered speaker in opposition as well, if you
Okay.
want to.
So, go to number 15. Number 15, 161 Lisker Street. Apparently, proper notice was not given. Mr. D'Oliveira? Yeah. So, this application has to be deferred? Do you have any comments, or are you, is the deferral acceptable to you and your client?
Yes, the deferral is acceptable to the client. This is public notice that was sent out by the city. Was missing the variances. There was an error here. It was sent out public notice that was sent out to all the neighbors, even though the one online was the correct public notice with all variances listed. So this is a technical deferral due to an error on the city side of things. They've already given us a new hearing date for October 27th, so I think this is more of just a formality of going through this process now during the year.
Yes. All right. Mr. Jangda? Mr. Jangda? You on the line?
Mr. Janda, you've been unmuted. If you can try to speak or maybe unmute yourself on your own device.
Hello, yes?
Yes, Mr. Jangda, this matter has to be deferred because the notice that went out was not proper. So it's being deferred to sometime in October. So are you agreeable to that?
Yeah, that's fine. I'm a neighbor. I live at 163 Lisker, so I was just here out of interest.
Yep, okay, thank you. Panel, do we have a motion for deferral? Yes, Joanne?
Yes, given the error in the notice, I move to defer the application.
Right. Seconder, Larry, all in favor? Have your deferral, sir, thank you. Now, go back to number 7. Or did we deal with 7?
Through you, Mr. Chair, we're on item 8 now.
Yeah, number 8, right. All right.
Is there still a request to defer on item 8, Mr. Chair?
I don't know. We'll find out.
I was just looking at the email of September the 16th. from
Yeah.
Christian Chan.
Yeah, I have a notice, so, a note that there was a request for deferral, so I'll introduce it and we'll get to the speaker and see what he or she has to say. So this is, number 8 is 199 Beach Avenue. The purpose of the application is to construct a 2-story laneway suite in the rear yard. We have material submitted by the applicant. We have reports from engineering and urban forestry. We have opposition from 204 Willow Avenue, 195 Beach Avenue, 205 Beach Avenue, 206 Willow Avenue, 208 Willow Avenue, and 203 Beach Avenue. Mr. Chan?
Good morning, Mr. Chair and committee members. This is Christian Chan, the agent and land use planner on behalf of the applicant, Lisker Street.
Yeah, can we have your address, sir?
My address is Suite 1381 at 157 Adelaide Street, West.
Okay. Yeah, are you asking for deferral?
Yes, pursuant to the email that Ms. Hayes mentioned, we are requesting a deferral of this application in order to revise the plans pursuant to discussions with community planning that occurred after the public notice had been circulated. Therefore, we require this request. And on top of that, Mr. Chair, in light of the 6 letters of opposition that have been received, this will also give us an opportunity to discuss the application with neighbors and potentially resolve the issues before returning to committee of adjustment for hearing on the matter.
Okay, good. Let's go to Mr. Lacroix. And,
Hi.
all right,
My
Mr.
name's Mr. Neil. I'm from 6 Willow
So,
deliver the notice of objection with respect to this variance request.
okay, so the applicant has asked for a deferral so that they can consult with the neighbors and deal with the planning. Do you have any objection to the deferral?
I don't on a personal level, but a lot of the things I referenced in my notice of objection are relevant to some of the other items you've discussed on laneway housing.
No, but we're not dealing, sir, we're not dealing with the merits at this time. We're just dealing with the issue of a deferral.
I have no objection. It would have been nice to know that earlier in the day and earlier in the session.
Well, it was in the material online.
Okay, I recognize that, but there was an opportunity at this commencement of this meeting where other matters were deferred at the onset.
Nothing was deferred at the onset. We discussed one, but it didn't get deferred at that point because there was nobody available. In any event, we're going to take it to the committee. Committee, do you have any questions, or do we have a motion for a deferral? Yes, Joanne?
Thank you, Mr. Chair. Given the request for deferral and the variances being requested in the opposition and the opportunity to have some conversations with planning, and importantly, those who have opposed and neighbors, I think it would be appropriate to defer the application to, if nothing else, provide clarity and an opportunity for discussion.
All right, seconder? Larry? All right, second. All in favor of the deferral? Jim? Are you in favor of the deferral? Yes, you have your deferral, sir. Thank you. Number 940 Bernard Avenue. The purpose of this application is to alter the existing 2.5-story semi-detached dwelling by constructing a rear 2-story addition with a new deck and a rear 3rd-story addition. With this application, we have material submitted by the applicant. We have a report from Urban Forestry. We have 7 form letters in support. We have opposition from many addresses on Bernard Avenue. Mr. Dom?
Yes.
Yes. We have your name, your address, and your presentation, sir. We have some opposition.
Yes, I understand that. Hi, my name is Joe Dome, 1101 States Avenue West, agent for the owner. I'd like to begin by stating that the owner has tried to speak to the neighbors and has gathered 7 letters of support from residents on Bernard Avenue on file, as you mentioned. Unfortunately, it's not always possible to agree with all the neighbors, and unfortunately that seems to be the case here with the neighbors who have commented on the application. I'd like to explain why this application is both reasonable and fits within the neighborhood context. The owner would like to create a comfortable and desirable family living space and decided that this current design of a 2-story addition and step-back 3rd floor addition meets those goals. The owner has corresponded with Heritage, where due to a technicality, it was determined that Heritage would not accept matching number 40's 2nd floor front addition as shown on the north elevation, A309. If you could bring that up. That would be A309, yeah, right there. You can see how the neighbor at number 42 has that front rear addition. Now the plans were revised to remove that aspect for number 40, and Heritage is now completely satisfied with the application as shown on the correspondence on file. Planning has no objections as well. To address the proposed depth variance number 3 of 21.93 meters for the 1st and 2nd floor, I'd like to point out that this addition matches the same depth as the other 2-story additions of the neighbors at number 38 and number 36, the latter of which was approved for a depth of 21.95 meters in 2019. And it does seem like there's a bit of an error on the site plan. The depth of 38 is basically the same as 36. The depth of the proposed 2-story addition will match theirs. As well, there are other dwellings on Bernard that have been approved for greater depths, such as number 13 Bernard, 22.4 meters, 19 Bernard, 28.66, and 28 Bernard, which was approved earlier this year with a 23.02 meter depth. The third-story addition is stepped back from the rear, and its depth conforms to the bungalow at 17 meters. So the third story would be as of right for depth. As far as privacy and shadows are concerned, there will not be a reduction of privacy over the existing or as of right conditions. There's no overall height variance and no proposed side windows on the addition. There's also significant large shading from multiple trees in the rear, and the property's all back onto a commercial building. If you could bring up the document titled Supporting Materials, you can clearly see the existing tree cover. I know there's a lot there. Okay, yeah, so this is facing toward the rear of number 40, and the bottom left image is pointing toward number 42, and the one on the right is pointing toward number 38, and you can see the tree cover there. And there's actually a lower angle that you can see on the next page, pointing toward number 38. You can see the significant tree cover, and the last photo there shows how the property's all back onto a two-story commercial building along with a large building next door. Now, as far as FSI is concerned, the existing FSI is 1.03. The proposal for 1.48 is not out of character with what has been already approved in the immediate area, including some significantly larger. Just hopping over to the next street south, number 51 Tranby has a 1.62 FSI, 42 and 33 Tranby have a 1.4 and 1.44 FSI, and the next street south has two dwellings over at number 10 and 12 Boswell that have 1.8 and 1.87 FSI, respectively. Finally, the side yard setback variance number 2 is an existing condition, and the rear yard soft landscaping variance number 5 is a relatively small reduction of 3% compared to other soft landscaping proportions, such as 28 Bernard again, which was approved for a 36.48% soft yard landscaping variance. Now, we feel that considering the specifics of this application along with its context, this application is reasonable and minor in nature, and I'd be happy to answer any questions.
Panel, do you have any questions? Okay, let's move on to Ms. Couture.
Yes, hello, can you hear me?
Yes, we can.
I will thank you all, and Mr. Dundas, a very persuasive presentation. As you say, it all seems extremely reasonable and consistent with all of the new additions that are going on in this neighborhood. Which
All
is
right, Ms. Couture,
Yes.
could we have your address, please?
Yes, I'm the owner and resident at 42 Bernard, which is the attached property to number 40.
Okay, go ahead.
Yes, as I was saying, this proposal sounds extremely appropriate and reasonable, but it doesn't feel that way to us and to the many neighbors on Bernard who support our position. What we would like and what we've done is proposed a compromise because we certainly encourage all neighbors to enhance their properties. In this case, however, this is being done to enhance the value of the property at number 40 to
Ms. Couture, we don't choose between alternatives. We can look at we have looked at your drawings, et cetera, and we look at them from the point of view of the impact that the variances would have on you and your property and your neighbor's property. But we don't choose which one we like better.
I see, so there's no potential for compromise in terms of.
Well, that's between you and the applicant. It's not for us.
I would like to underline then that the applicant never reached out to us. I've been told by neighbors that he's gone to other people to say that these additions match number 42, which they don't. So there's been unfortunately an unwillingness, I suppose, on his part to discuss this with us, and we have not been able to reach him.
All right, so this is your opportunity to tell us what the negative impacts would be on your property.
We find that the size is excessive in comparison to number 42, as the third floor goes way beyond the dimensions of number 42. There is as well a new second floor which would go above a kitchen addition, which again, I'm not aware of what guidelines suggest what is minor and what is major. In our case, what we are requesting is that these plans be amended rather than approved so that they would be consistent with the property next door to which they are attached. So we're asking for the objection to prevail and to require that the neighbor consults with us to come to what we feel is an agreeable compromise.
Okay? All right, panel, do you have any questions? So I just wanted to ask Ms. Couture, you say and I noted in the file that this property is allegedly for sale. Is there a for sale sign in front of the property
Yes, there is.
today?
Yes, and if you look at the website where the property is listed, it says that plans are being, and permits will be part of the sale.
Okay, thank you. Mr. Dom?
Hear me?
Yes, we
Hello?
can. Yes.
Okay, great. Yeah, so I would like to respond to the neighbor's comments. Now, the owner does acknowledge the neighbor concerns, and he said that the neighbor at number 42 did not try to contact him, and he did go around to other neighbors. Of course, he's aware of the opposition in the area, and it has been the case for other applications as well. But I would like to just point out that regardless of ownership, the design philosophy for this proposal is to create a comfortable and desirable family living space that does fit within the neighborhood context, and that's demonstrated by heritage and planning having no concerns, along with matching depth to the next door neighbors at number 38 and 36 of their two-story additions, and the aforementioned examples of both on the street and in the surrounding area. And I have to say, it does seem a bit strange, at least in the opposition letters that have been posted so far, that some of the neighbors enjoy existing depths of two-story additions that are identical to what is proposed here, such as number 36, which was approved only 2 years ago, with the depth variance for their two-story addition clearly listed on the decision notice as 21.95 meters versus the 21.93 meters that's proposed here. And also, once again, privacy and shadows would not be affected much due to the significant tree cover and the commercial property to the rear. And also, the third story is stepped back, so it does not go out the full distance. It's stepped back to conform to the bylaw for depth as of right at 17 meters. And I think that concludes my remarks to the committee.
So I just wanted to ask you, Mr. Dome, you cited some properties on Tranby and Boswell which had a floor space index greater than this property or the proposal?
That's right.
Okay, so I understand that Tranby and Boswell have very small lots which would inflate their floor space index. What size is this lot?
This lot is lot area 218 square meters.
So what's the frontage and what's the depth? That has more meaning to me than square footage, square area.
Yeah, the frontage is only 6.36 meters. The depth is 34.52 feet.
Okay, all right. So I understand the size of the lot. Panel, do you have any further questions? Yes, Larry?
Yeah, if I wouldn't mind, so I'm struggling because I think I'm hearing two very different versions. I heard the agent say that this addition wouldn't be going out any further than 42, and I thought I heard the owner of 42 disagreeing with that. So I wouldn't mind if someone could just confirm, you know, the rear addition, and is it mirroring what's at 42, or is it different?
So, Larry, I thought that the agent said it was the same depth as 36 and 38, not 42.
So that's what I'm trying to confirm, because the owner of 42 seemed quite concerned about that.
Okay, I can clarify that. Can you hear me okay?
Yes?
Yep.
Okay, yeah, I can clarify that. So the two-story rear addition goes out to where the existing one-story rear addition for 42 goes out to, but it does match the two-story additions that are already existing at 38 and 36 on the other side.
So is it a two-story addition that goes on your property that goes back, or is it a three-story addition?
So the two-story addition goes back further, and that's the one that that is affected by the depth bylaw, whereas the third floor does not go past 17 feet.
Okay. All right. Are you clear now, Larry?
Yes, thank you, Chair.
Yeah. Any further questions? Joanne with us?
Yeah, my camera seems to have frozen, but I'm here. I just
Oh.
had a question,
Yeah.
and I'll pick that up in a second. I don't know why that happened. It must have missed it. I didn't see an east elevation drawing in the package. Did I miss it, or was it not provided?
It doesn't seem to be included in here as well, but I can assure there's no windows on that side.
Okay. Any further questions or any comments? There you are. Okay. Do we have a motion? Yes, Yim?
Can we have a discussion? I'd just like to, I do have a motion if anyone finishes comments. What I want to say that if both 42 and the proposed 40, they actually step back, and the only difference is that it's 42 and they step back 1 story at the back. And now the proposed one is the second story goes all the way back, so the length is the same. But I was hoping that the opposition will help us, the no impact of that extra second floor, sticking out on them. But I did not hear if they will only satisfy if the co-post is exactly floor matching theirs. But in terms of impact, I did not hear anything about shadow, or that is the view that they cannot see anyway. So, I didn't hear that, and it seems that in terms of impact, I did not hear. That's what I wanted to mention.
Okay. Larry, did you have a comment?
Yeah, first of all, I want to thank everyone
to make a motion, Larry?
I'm happy to do so if no one else has any comments. I'm prepared to move approval of this application subject to forestry condition number 2.
Do we have a seconder? Yes, Yim? All right, all in favor? All right, you're in favor, Joanne?
I
Yes.
just wanted to, just ask one thing with respect to screening on that third floor balcony. Because of the inset of the neighboring semi, I just wondered on the, at least the east side, but probably the east and west side, that would you consider amending your motion to add the privacy screening?
Yes,
Yes.
thank you, Joanne, that's an excellent point. We'll make that a condition.
What side, Larry?
I think both Joanne is saying east and west.
Okay. Yim, are you in
Yes.
favor of that? Okay.
Yes, 1.5 meter from the back, right? That's
Yeah, the standard.
Yes. Okay. All in favor of the motion? You have your approval, sir. Thank you.
Thank you very much.
Okay.
Through you, Mr. Chair, I believe we have to take a short break to address some audio issues we are experiencing on YouTube.
Okay. That's good. All right. How long do you need?
About 10 minutes.
Good. Okay. We adjourn for 10 minutes.
Test.
Mic check 1 2. Audio checking 1 2 3 4 5. Audio check 1 2 3 4 5 6.
Dawn, it's nice that we can see your face now. We've got a close-up of you now.
Yeah. Okay. There we are. Okay. Are we okay to go back on? Gentlemen, are we okay? Okay, we're back on. We're going to deal with numbers 10, 11, and 12, 720, 722, and 724 Queen Street West. The purpose of number 10, the application is to convert the existing commercial space located on a portion of the ground level and the complete second level of the building municipally known as 724 Queen Street West into a restaurant. The space would be occupied by the expansion of the existing Toroni restaurant municipally known as 720 and 722 Queen Street West. With this application, we have material submitted by the applicant with respect to all three applications, 720, 722, and 724. Just material submitted by the applicant. Mr. Mackay. Mr. Mackay on? Okay. Okay.
Hello, Mr. Chair. It's David Mackay. I'm a registered professional planner with MEPC, and I represent the owner of the property on Crescent.
Okay. perhaps you could give us, what's your address, sir?
It's 7050 Weston Road, Suite 230.
Okay.
Perth, Ontario.
All right, so perhaps you could give us an outline of what the proposal involves.
Sure, thank you, sir. I did provide a presentation. I don't know if it's on, can be brought up, but in any event, I can quickly go through it. The proposal, Troni Restaurant has been in this area for over 20 years. They have, as you know, become, thank you very much, committee staff. As you can see, it is a Main Street area along Queen Street West. As the business has become popular, they've grown to adjacent spaces. So they currently are operating at 720, 722, a portion of 724. 724 came up for sale, and they were able to buy the building and expand it. And so this expansion adds 130.8 square meters to the building on 2 floors to the restaurant space. And what that allows them to do is to provide a bit more seating, but also update their kitchen, which was in a very confined space, as well as fix a number of the accessibility matters within the space itself, including providing for an accessible washroom on the main floor. As shown on the drawings, and if you want to flip to the third page, please. You can see that there's the existing space on the ground floor in gray. That's the existing commercial space, so that it's being taken up, and that will be converted on the bottom portion of the screen for a proposed dining area and wine tasting area. If you go to the next page, please. On the second floor, you can see that we're expanding into 724 to provide for another dining space, but to relocate the kitchen and expand it to so it's a proper working kitchen rather than what it is today. There are no exterior expansions to the project, and really the intent of the limitation was to prevent large nightclubs and noisy restaurants from coming forward and in near residential areas, creating noise and litter concerns, and not to deter viable businesses such as Troni that have been good neighbors in the past and going forward in the future. In fact, if these lots were slightly larger, you could have 3 restaurants up to 400 square meters each on each lot. And the only issue here is that it is combined, and that's what creates the variance that's before you today. So we would request approval of the application, and I've outlined how it meets the 4 tests in my covered letter submitted with the application. Be happy to answer any questions that you may have.
Committee, do you have any questions? Yes, Yim?
Just a quick question. You have been working with community planning and they do not object to this proposal?
That's correct. We did speak with planning staff on this, including heritage staff, and we're able to work through any of their concerns, and obviously they have no objections or conditions applied to the variance request.
Any further questions? All right, let's go to Ashley Wiley.
Mr. Chair, actually that person was registered by mistake, and it's for a different item later today.
Okay, so you've got her listed somewhere else? Okay, thank you. Okay, so there's no further speakers on this matter, or these matters, so let's take it into committee, unless you have any further questions. Do you have any comments or a motion? Yim?
Yeah, okay, if that, I think, as a comment, I'd like to move approval. The reason why I asked my question was that I know there's a comprehensive study few years back and established the maximum size of restaurant. So, as long as they have worked with community planning and they're satisfied with it, it's a very popular restaurant. We You know, the kids book on the way, and then we just say, okay, let's have hamburgers and stuff. Okay, I move for approval with no conditions.
Okay, so, Jim, yeah, I just want to ask one question. Are all the, I haven't read them in detail now, are all the variances in each of the three applications the same? Or do we have to do it one at a time? Can't hear you, Yim, you're muted.
What proposal? Because they intertwine, sort of merge the two property. I think the plan sort of apply to all three that addresses all applications.
Okay, so we're dealing with application number 10, 11, and 12.
Yeah.
Okay.
That's what I thought, Chair. I thought we could probably handle all these three, and I'd share Yim's observation that it is very popular and it is very difficult to get a seat, so this can only help all of us.
Well, I live down the street and I haven't tried because it's been closed since I moved there for the most part. Okay.
I second Yim's motion for all three.
Okay. All in favor? Have your approval, sir. Thank you very much.
Thank you very much, and hopefully we'll find you a seat. Have a good day.
Thank you. Number 13, 63A Wayland Avenue. Purpose of this application is to construct a two-story detached garage in the rear yard of the property. The garage will contain one parking space on the main level and a laneway suite on the second level. And with this application, we have material submitted by the applicant, a report from engineering, and correspondence and concern or interest from 71 Wayland Avenue. Juanita Koo.
Sorry, Mr. Chair, through you, we also have correspondence in support from 65 Wayland Avenue, as well as 13 signature petition in support. And that was submitted after September, or just the past couple of days, September the 27th.
Thank you. Ms. Koo?
Thank you, Mr. Chair. It's Juanita here.
Yes, can we have your address?
I live at 63A Wayland Avenue.
Okay, so there is some opposition, so can we have your presentation as to what this application is about?
Sounds good. I'm going to have my husband, Steve Forrest, speak on my behalf.
Okay.
Mr. Chair, Steve Forrest, 63A Wayland Avenue.
Yes.
Oh, yeah, we're looking for approval to build the two-story laneway suite, just in our back laneway. I read the concerns of the letter, and I addressed with him as I went to go talk to him, and he mentioned I addressed the concerns, and he was okay with it when I talked to him. However, this letter went in before I actually talked to him, so.
Okay. So, your variances are rather minor, and
Yes.
so, all right. The panel, do you have any questions of Mr. Forrest? Okay, let's move on to Jen McKay-Berry.
Hello, can you hear me?
Yes, we can. We have your full name and your address for the record, please.
Yes, it's Jen McKay-Berry. I'm a neighbor at 63 Wayland Avenue.
Okay.
And in general, I don't have any major concerns with the exception of the fact that this, when the drawings were fences, or a fence, sorry, and trees and a couple of dogs, so, just the least amount of interference with, my property would be, desirable, to say the least.
Right,
I
so,
think
but that's, Ms. Barry, that's not anything that we can do anything about. We just deal with the variances. I appreciate your concerns, but,
But why use property?
pardon?
This is showing that it's actually going onto my property, that's my concern.
Yeah, well, that's something you have to take up with the owner of the next door of the property doing that, and, but it's nothing that we can do about, do anything about, we only deal with the variances.
Is the variance not to do with the width of the structure itself?
Well, the variance only deals with the side lot line, not, and it says goes to 0 meters. It doesn't say it goes over.
But if you look at the drawings, it clearly goes over.
Oh, Mr. Speaker, may I interrupt?
Yeah, okay.
Sorry, myself and and Jenny, we had a conversation a couple nights ago, and I did assure her that we were going to make sure the structure was completely on my property and not bordering the property line. And that night I did send a email to my architect to make that change, which I haven't received that file yet, but it has been addressed.
Okay. All right.
Just my only concern is that I didn't want, I wanted to ensure that the drawings showed that I was not losing property. You know, I don't know how this works in terms of legal stance, but
Well, you have every right to ensure that they don't build on your property, but that's not something we can address. So, Mr. Forrest has taken it up with his architect, and I'm sure you're going to be able to work it out. Okay, so let's move on to Pamela Dell.
Mr. Chair, Pamela Dell is not in attendance. I have sent her an email and tried to call her, but no response.
Okay. All right. So we've heard from Mr. Forrest about Ms. Berry's concern. So I don't think we need to go back to him. So we can go into a committee. Do you have any questions, Larry?
Just a technical question about the concern raised by the neighbor. We're looking at drawings which appear to have the structure go over the property line. Notwithstanding it's not a variance before, can we approve something that actually appears in a site plan to be incorrect? I just asked the question. I look for some advice maybe from staff.
I don't know that we're approving site plans. We're
Well, but
approving.
the site plan is part of the application though, right?
Yeah, but we don't vouch for the accuracy of all the drawings. We just deal with the variances.
Okay.
So, but certainly Miss Barry is on it, and Mr. Forrest is aware, and they seem to be working it out. So, but certainly we're not going to approve something that goes beyond the lot line, and that's not what we're being asked to do.
Okay.
So, Sabrina, do you have?
Through you, Mr. Chair,
Yes.
just to add, if the applicant wants to submit a revised site plan that shows the structure completely on their land, then perhaps that would help the situation.
Yes, my intent is to submit one. I'm just waiting for my architect to update the drawing, really.
Panel, do you have any? Joanne?
Just a couple questions. I noticed that with respect to the side yard variances, I understand that or it would appear that the garage on the neighboring property also goes lot line to lot line. Just want you to confirm that. But the depth that you're proposing, I don't see from the information that we've received is representative of other built forms. Can you give me some examples? And also, can you address the concern that was raised with respect to proposed business use?
Yeah, so sorry. I was looking at the drawing that was up on screen there. Yeah, the neighbor's lot, or the neighbor's garage is right next to the property line as well, on the north side, I guess, there.
Yeah.
So yeah, they're gonna be fairly close together. Sorry, what was the next question?
Second question was with respect to the second variance was with respect to the size.
The size. So I made the second floor has a cantilever of 0.97 meters. That's just to make the bedroom a functional size for a normal sized bed and side tables and whatnot.
Okay, so it's only with respect to the cantilevered section on the second floor.
Yes.
And what with respect to the concern with respect to business operation?
Well, we're building this for my mother-in-law to eventually move into next few years. But in the meantime, I said, well, I am an RMT, so I can use it while she's not being used right now, just in lieu of her time. Just instead of having it sit empty for a little bit. That's all I was saying.
Is a business use permitted in that?
Well, no, but I don't, like, right now I see people in my house, which in a smaller room that doesn't have a lot of space or privacy, so I don't see the difference. Yeah.
Thank you.
Jim?
Are we in committee? I'd like to address the comment by Joanne about commercial use. I do not think in the application anywhere mentioned it's allowed. And I think that in the light of that, maybe we have to put a condition that it's not for commercial use because it's not meant to be commercial for living use. I feel if we were going to consider this would be one of the conditions that we need to.
Well, I would, there are some home offices and other types of activities that aren't necessarily considered required to be in a commercial zone. So I'm not sure what all you're entitled to do in a residential zone, but I assume that Mr. Forrest is entitled to see some of his clients in his home, and I don't see any difference if he can see them in this suite, laneway suite. But if that's the sole purpose of it, then you're quite right, it's not a residential use. But I think it depends on the definition. Perhaps Sabrina could help us with if this would offend the residential purpose of the laneway suite. Maybe Mr. Forrest, you could tell us how often you intend to see a client there.
Yeah, it'd be very occasional. It'd be if I can't get to their place or they can't get to the actual clinic I work at, due to scheduling conflicts, then it'd be occasional, a couple hours a week, 2-3 hours a week, maybe.
Yeah, Chair, I'll just weigh in. I'm just looking at those. It's a legitimate concern but I'm looking at the floor plan for the residential portion of this, and it would appear, at least from the drawings, that it is a residential type use, given the kitchen and the layout of the bedroom and such in the bathroom. Generally, I'm not terribly concerned about the interim use. It's going to be occasional, and the configuration implies that it is ultimately for residential use.
And yes, I agree with that. But what I'm saying is you're absolutely right. If you look at the application, there's no mention of any commercial component. It's purely just residential. I do not know where this part of the discussion came into, because if we were going to approve the application, there's no mention of the use can be used as commercial anyway.
The only reason I raised it is because one of the letters of objection spoke to the use of a yoga studio, and when I looked at the plans, I didn't know what the use of the basement was for. There's a full washroom down there that doesn't have any development. That was the reason why I asked the question, because it was raised in one of the letters of objection.
Yes.
But
Sorry,
I think that it is looks like it's designed to be a residential use, and I think the applicant would have to seek any necessary permits or comply with the zoning if he intended to use it for other purposes. But I think the variances are what's before us right now, so.
It doesn't seem to be an occasional use because of scheduling problems. Does not seem to be the operation of a business that requires commercial zoning.
No, that's my point. That's what I was trying to say, Carl. Dawn, sorry.
Yeah.
But you said, Dawn said that someone mentioned that it's going to be a local studio that will increase the number of
Well, I've seen that's what they were suggesting. The applicant has now clarified what his intention is.
Maybe just to kickstart this, then I'll happy to move approval of this application. I think it's a reasonable application. There is no height variance, and the length, I think, is existing conditions. So I'm happy to move approval of this application subject to the standard engineering conditions.
Larry, just with the applicant, it said with respect to the length, it was only with respect to the cantilever portion on the second floor. I know we've got a difficulty with respect to the accuracy of the plans and the property line, but would you be prepared to restrict the depth to the second floor cantilevered section?
Yeah, sure. That's a good point. Maybe I'm happy to make that as a condition that the depth variance is subject to the second story.
Yes, Joanne, are you seconding the motion? Okay, all in favor? Have your approval. Thank you. Number 14. Oh, pardon me, Larry. Did you make the engineering conditions a condition of your approval?
I did, Chair.
Okay, thank you. I missed it. Number 14, 3 Glen Rose Avenue. Purpose of this application is to alter the existing 2-story detached dwelling by constructing a 3rd-story addition and a 1-story front addition. On this application, we have material submitted by the applicant. We have a report from Urban Forestry. We have support from 2 Glen Rose and a 15 signature petition from properties on Inglewood and Glen Rose, and correspondence and concern or interest from the Moore Park Residents Association. Mr. Woods?
Yes, thank you very much.
Can we have your address for the record, please?
I'm the homeowner at 3 Glen Road.
Okay, so you have some opposition from the Ratepayers Association. Could you give us a presentation?
Sure. So my wife and I purchased our home in 2015, shortly after the birth of our twin daughters. And we thought at that time, perhaps naively, that our home and its purchase date would be our forever home. Unfortunately, as our children have grown, it's become a little bit too small. And whether it's our new work from home reality, the limited closet and storage space, or the fact that the 4 of us are sharing a bathroom, it's becoming more and more challenging as the girls age, and as they approach their teenage years, it's going to get even worse. We've built sort of a strong community already, and we have sort of a deep tie to the area. We love the girls' school, we're members of the local faith community, and we are participants in neighborhood activities and holiday parties, solstices, things like that, that go on in the neighborhood, pre-COVID, obviously. We've considered our 2 options, being moving or renovating, and moving for us is kind of the worst case scenario. And even though that is the case, we've looked in the neighborhood and we've been priced out of the homes that have come up. So we're kind of stuck with the option of renovating. And we put a lot of time and thought into how we can improve the utility of our home or our family while fitting into the look and feel of the neighborhood. Our house and the lot are the smallest on the street and will continue to be after the renovation. We have a shared driveway with garage parking for 1 car, and there's no street parking. So outdoor storage options are also limited. We have no backyard, and our attic space is unusable. So the only real option we have is to go up. 21 out of the other 24 houses on our street, and this is on Glen Rose from Inglewood to Mount Pleasant, have a 3rd floor already. In addition to the 3rd floor, we're asking for the committee to allow for a small bump out of the front door to provide room for some extra storage, but we made sure in our plans that it didn't extend beyond our current bay window, so that we keep with our existing setback. Before submitting anything to the committee, we contacted our neighbors, the ones that we thought would be directly impacted by the changes, to make sure that they were comfortable with our plans. These are the neighbors beside us, behind us, and across from us, whose sight lines, views, and privacy could potentially be impacted by our renovation. And they are the ones that will have to look at our house every day. No one objected or shared any concerns with us. And I'd like to bring your attention to the emails, the comments, and petition of non-objection submitted as part of our application. So it's with the support of our neighbors that we ask that the committee approve our requested variance and allow us to move forward with our renovation.
All right, panel, do you have any questions of Mr. Woods? Yes, Larry?
Just a quick one, Chair, if I might. Could you just, do you know what your existing FSI is?
I think it's 0.76, something around there.
Okay, thanks.
Mr. Bogdan?
Hello, hi, it's Gordon Bogdan here. I'm the president of the Moore Park Residents Association. Speaking on behalf of Jeremy Gollum, the chair of our planning committee and development committee, who's unable to attend the sessions today.
Go ahead, sir.
Oh, thank you. As the committee and the panels were seeing, a letter was submitted by the Moore Park Residents Association with an objection to the proposed development and the renovation here. And just to step back for a minute, we are trying to be consistent with our position we've taken on other files that been before the panel many times, and the panel's familiar with us. And we virtually never objected to any variance under 0.8. In this case, and we've certainly seen a trend toward objections in those cases, and we've, you know, worked with the owners and architects, and we've supported concessions then with our, you know, in that 0.8 to 0.1 range. And notwithstanding, we note the support of the renovation, the support of these renovation plans from the immediate neighbors and other neighbors in the vicinity of 3 Glen Rose. In this case, when the FSIs moves over 1 to 1.13, we just felt it necessary to, you know, state our objections because of the overall precedent this sets for, you know, our overall neighborhood in Moore Park. These, you know, these variances have just been creeping up, as the panel's aware, for years, and this pushes really over what we believe is a reasonable ratio, a reasonable limit. And we have, as you've seen in the letter, there were, and not by me, there was an approach to the architect to relay these concerns with some suggestions, and those suggestions, I understand, the owner wasn't going to consider that. We offered to have a meeting with the owner, but that couldn't be arranged. So that's our position. It's really looking not to be setting a precedent for other development in the neighborhood of Moore Park, exceeding that 1.0 FSI ratio, which this application does by quite a bit.
Mr. Bogdan, we heard from Mr. Woods that his is the smallest lot and the smallest house on the street. And we know from our experience on the committee that when you have a small lot, anything you do exaggerates the floor space index. So are you just looking at the number over 1, or are you looking at the whole picture and seeing how does this house, if completed with the renovation, how does it compare in terms of size to the neighbors?
Very good point, and to be fair, Mr. Chair, I'm not familiar with all the specifics of the homes on that street. Our discussion around this was centered around the number, the 1.13 FSI that these renovations would require. So it's that precedent that it's setting, just going forward, and we were just suggesting that some concessions, the owner would be prepared to make some concessions on some of that space to just reduce that.
Yeah. Well, when you're working with a small house and a small renovation, you may not be able to reduce it much. I don't know, but in any event. So let's go back to Mr. Woods. Do you have any comments on Mr. Bogdan's submission?
Yeah, and I want to sort of address the comment from the outset that we weren't willing to consider the Residents Association's suggestion. That's actually not accurate. They did speak with our architect, and they provided a suggestion of what we should do. And their suggestion was essentially to build and use the current attic space in order to build this existing floor. But in discussing with our architect, it's just not feasible to do it the way that they had suggested. So while we considered it, it's just not possible for us to add the extra space doing it the way they suggested. So we have no choice but to go up, which once we're going up, it's sort of, I mean, to cut here and there seemed, you know, in order to reach some magical number of FSI just seemed, you know, I'm not sure it really would make any appreciable difference, you know, within the variance itself. We would still have, as you noted earlier, we would still have an FSI that would be, you know, in the view would look unreasonable from their perspective. So I think, you know, for us, you know, we look at it from the perspective of how this fits into the street and what our neighbors think. And ultimately, we have the smallest, like if you look at the drawing that's up right now, our lot cuts in on an angle at the back. We have no backyard. space that's there is basically our ability to drive into our garage. So yes, we have an FSI that looks somewhat unusual, although given some of the numbers we've seen earlier this morning, you know, numbers as high as 1.6, our 1.13 doesn't seem that out of whack in terms of what's going on in the city. But even from the standpoint of looking at it from the street, you wouldn't know, looking at our house from the street, that we have greatly exceeded, you know, or gone over the FSI from the Moore Residents Association's perspective, that we're way out of whack with the rest of the neighborhood. I don't agree with that. As I said in my comments, we have a very tiny lot, the smallest in the neighborhood, so we don't have the benefit of defraying some of that ratio with backyard space. So anything we do, any addition we make is going to create a problem, and we already have. I mean, we're already over the limit without having done anything. And so, you know, I respectfully disagree with the Residents Association, and I think, you know, from the standpoint of our street, you know, our direct neighbors, the ones who are going to have to see this every day and live with us, you know, in this renovated house every day, are the ones that should be given more weight in terms of their views on this compared to the Residents Association, which is, you know, while we appreciate their work and we value the work that they do in the neighborhood and keeping it and preserving it, we think that, you know, given the uniqueness of our lot, this isn't something that's going to create a precedential effect within the neighborhood. This is just a one-off given the size and uniqueness of our lot.
All right, thank you. Panel, do you have any questions? Yes, Yim?
Yeah, one question to the applicant. Can you tell us that there are 4 variances? Some of the variants, I believe, they are triggered by existing condition. Can you point out which ones are?
Yes, that's correct. So my understanding is the house, like if you go the frontage, sort of the setback of the house is, we're keeping it the same. The sidewalls we're keeping the same. The eaves and the overhang are already abutting against our neighbors, so all of that is all the same. The front yard, we're keeping the yard. We have to rip up the existing walk we have to rebuild another one, but it's staying exactly the same as it was in terms of the stone walkway. So we're not taking out any yard in order to bump out the front a little bit. And as I said before in my opening remarks, we're not getting any closer to the street. We're just going to our existing point with the bay window. And it's not even going out as far as the full extension of the bay window. It's just sort of squared off with the start of the bay window.
Thank you. Yeah, that's what I'd like to see.
Any further questions, or do we have comments or a motion? Larry?
Joanne, you want to go ahead?
Sure. You know, I would agree that on the surface, the FSI, you know, looks a little large, but in the context of the lot and what's being proposed here, I actually think that the design is quite sympathetic to the existing character of the street. You know, there are many large homes on this street, and one just further down is narrow and quite tall as well. I am in support of the application, and if my colleagues have no further questions, I would make a motion to approve the application subject to forestry condition number 1.
Do you have a seconder? Yim? Yim?
I will second it, and also I'd like to add my comment with my notes. I actually said this is a very sensitive and well thought out addition, and I do value all the support they have in the immediate environment, and I appreciate that Residents Association's job in vigilant, but in this way, in this case, this development has a lot of merit
approval, sir. Thank you. Number 15 has been dealt with. Go to number 16. (1083) to 1085 Dundas Street West and 14R Halton Street. Purpose of this application is to convert the existing one-story commercial building from an auto repair shop into a fitness club. The existing rear vacant lot, municipally known as 14R Halton Street, would be used for off-site parking to serve this fitness club. With this application, we have material submitted by the applicant. We have email correspondence from planning and transportation services, a report from planning, and support from 246 Shaw Street. Mr. Cronus.
Yes.
Sorry, through you, Mr. Chair. We also have some supplementary materials that were submitted, both a covering letter and landscape plan from the agent, correspondence in support from 254 Shaw Street, correspondence in concern and interest from 250 Shaw Street and 246 Shaw Street, as well as correspondence in opposition from 20 Halton Street.
Thank you.
Yes, good afternoon,
Mr.
Chair.
Cronus, please.
Ready? Yes, can you hear me, Mr. Chair? Hello?
Mr. Cronus, you've been unmuted. Maybe just check your... Oh. Okay, if you can try again. Because we can't hear you.
Can you not hear me?
I do have your number. I'll try to give you a call so that you can join calling it.
So just to be, I heard him on my so.
I heard him as well.
Can you hear me now?
We can all hear, but the staff is my problem.
Okay, I don't know how you wish to proceed. Mr. Chair, can you hear as well? I guess not.
So
Okay.
I think one of the staff are gonna try and give you a call. Is that okay?
Yes. Hello? Hello? Yes.
Okay, Mr. Cronus, you've been unmuted on your phone if you want to try to speak.
You want me to use the phone? How is this now? Hello? Mr. Chair, can you hear me?
Don,
Hello?
can you guys not hear him?
Okay, so we can't hear you at all.
How is this now?
I can hear very clearly.
What? So I don't know what's wrong at the staff level.
If you could just check that you're not muted on your device.
No, my device is not muted. My device is not muted.
Yeah.
All right, Graham, can you hear us?
We can't
They can't hear
get
us.
him.
I don't think they can hear
Oh,
us.
they can
either.
hear him outside of the room. So it might be wrong. We can't hear anyone actually.
I think it is the
Is this our-
so-called Zoom cannot hear us. We can all hear each other.
That's interesting.
It's. Can one of the committee members just talk to see if we can hear you?
Can you hear me? It's Joanne.
Okay, it looks like we have sound issues in the committee room.
Okay, how should we proceed?
I
Okay, I think we're gonna need 5 minutes just to fix the sound issues that we're having in the committee room. 5 minutes should be okay.
Okay, I'll just stay on the line.
Yeah, you should.
Okay, thank you. hear me now? Mr. Chair, can you hear me now?
Yeah, like a ventilator, something was like.
Paul, I can hear you, but I don't think they can hear you yet.
Okay.
Was it before with the sound?
Kind of strange, we finished something, everything was fine, and then, you know.
Okay, I could hear you
Could someone try to speak to see if we can hear you now?
Hi, it's Joanne. Can you hear me?
Certainly can hear you.
Okay, that's a good thing.
Yeah,
Hello, it's Paul Cronus.
we can hear you too. Yes. Okay,
Oh,
but,
sounds like we're live.
yeah, but let's just wait till we make sure all our panel is here before we go back. But it seems to be okay now. So, Yim and Larry, you're here? Okay, Joanne, are you still here? Joanne? Yep, okay. All right, Mr. Cronus, please let us have your name and your address and your presentation, sir.
Yes, good afternoon, Mr. Chairman and members of the committee. My name is Paul Cronus. I'm a registered professional planner. I've been with Weir Folds. I'm here representing the applicant on this matter, Anticipation Holdings Corporation. My address is 66 Wellington Street West, Suite 401. And I'd be happy to give your presentation in-depth or otherwise. To start off with, the committee may be familiar with this particular address. It was before the committee last year on a request to convert the existing commercial building on the property, which has been historically, and thank you to the research by Mr. Andrew Wynn, indicated that it's been a commercial use since 1925, I believe, about 96 years use as a public garage. It used to be one of the former showrooms. It stopped being used for that purpose. The clients have not had any interest from anyone to reuse it as a public garage, and they sought to convert the existing building to another use. Initially in 2020, it was for the purpose of a restaurant. That was refused by the committee, and the client decided not to pursue that on appeal, but rather work with the community and found another use, which happens to be the, as you know, the academy, the fitness club. The fitness club, for the committee's information, was once at the northwest corner of Ossington and Dundas Street, about 300 meters to the west. That site was redeveloped, and so they relocated to 64 Ossington Street, where they have currently a two-story building, approximately 500 square feet of space. That two-story building has been proven to be a challenge to run a fitness club, and they've shown a desire to relocate to this space. The use, the variance 1 and 2 deals with the use of the building for the converted dwelling to a fitness club, and variance number 2 deals with the fact that it's a non-residential building in a residential zone. Variance 3 and 4 deal with the off-site nature of the parking that's being proposed at the lot on the south side of the laneway system of 14R. And variance 5, 6, and 7 all deal with the same thing, and that's the setback requirements for a ancillary outdoor area, parking area, which is proposed at 0 meters as shown on the variances. So in totality, perhaps one can say that there's a number of variances, but if you bundle them together in that sense, you can see that it's really to address the redevelopment and repurposing of the existing building. Only internal renovations, nothing to the exterior. Mr. Wynn had indicated that the facade is appealing, it's got historical character. We agree that's to be retained. As you know, there is no issue from transportation. There are 6 parking places required, 7 have been provided. Planning staff and board support the application subject to 2 conditions. The second condition relates to a landscape plan that we filed, trying to address the comments, not just by the planning department in terms of having some soft landscaping, but also the concerns by a couple other neighbors, Mr. Roca at 246, which in response to those concerns, we sent in the letter to the committee, and we attached the landscape plan. We've addressed each and every one of his concerns. I've had dialogue with him over the phone, and he's satisfied, and I think he subsequently sent in an email confirming he's satisfied, subject to the landscape plan. What we did is on the east side, you see, we provided a 1 meter setback. His concern is the laneway is tight. It's an inner city laneway. It's a 5 meter laneway, and he
Then we had the letter from one of the other neighbors, Ms. Fung, that I'd be pleased to address. I too have reached out to her, but unfortunately we haven't connected. She indicates more or less the same concerns that were expressed by Mr. Roca. The change of use. This is an established fitness club that's been in the community for over 10 years. It's coming back to its former roots, closer to where they were before. The parking is to be used by staff only. Over 75% of the clientele is from the community. They'll either walk, they'll bike, or they'll take public transit. The space here represents a reduction of about 1,500 square feet from what they had before, or where they're currently at now. Of those that drive, most of them come, they're fitness clubs, so they don't like to drive. They do other things to get to it as part of their training. But those that do come by rideshare. So we've had no issues with parking at all at the other facility, and which in fact was approved by the committee to have a zero variance in parking at 64 Austin. In this instance, there's 7 spots where 6 are required, and we're not encouraging any of our patrons to show up.
All right, Mr. Cronus, your time is up, so if you could just wrap up.
Yes, I would say, Mr. Chairman of the committee, that I've looked at this, we filed a letter of support, it meets the 4 tests, and we hope that we can find a good repurpose of this building by allowing it to be converted into a fitness club. I'd be pleased to answer any questions that you may have.
All right, I have a question, Mr. Cronus. The variance number 2, you talk about the converted commercial building will be a non-residential building in the residential zone, but yet you told us it's been an auto repair shop since 1925. Is this not a legal non-conforming use?
Yes, the existing use is a legal non-conforming use. And so we're converting it to a use that is more compatible with the neighborhood.
No, I understand variance number 1 you would need a variance to get to a fitness club, but I don't understand variance number 2 because you shouldn't need a variance, I wouldn't think, to go from a commercial building to a commercial building.
Well, I would agree, sir, but this went through a preliminary project review, and the examiner was consistent with the last round of the zoning reviews that they did on the restaurant, and consistent with this one. If you look at chapter 1010-2040, sub 1 of bylaw 569-2013, you won't find non-residential buildings to be listed as the types of buildings permitted in the residential zone. Therefore, that kicks up the need to say, despite the fact that you're not allowed to have a non-residential building, you need a variance to permit it, although it's been there for almost 95 years. It's the way that the zoning people interpreted the bylaw.
Okay. All right. Thank you. Panel, do you have any questions of Mr. Cronus? All right, let's move on to Padraic Lally.
Mr. Lally, you've been unmuted. If you could try to unmute yourself on your own device.
Weil?
Mr. Weil won't actually speak. He's reached out to us to let us know that he won't speak during this hearing.
He won't speak?
No, and Ms. Fung actually left the hearing. So I think we have Bill Whipple.
Whipple?
Yeah, I think so.
Okay, let's hear from Mr. Whipple.
Good afternoon, everyone. Can you hear me okay?
Yes, we can.
Fantastic. Thanks so much for being available, especially during this incredible pandemic mess. I'll try to keep my remarks brief, and on point.
Can we have...
I'm in opposition. First of all, my name's Bill Whipple. I live at 20 Halton Street. I live in Owen. My house's garage abuts the alley that big developments and redevelopments like downtown lumber right just at the end of Halton Street. And as one of my neighbors often characterizes, it sounds like bringing Ossington to our doorsteps and to the doorstep of the park. Our tree canopy is under attack. That's a whole other story. But a lot of pressures. Number 3, parking spots. Let's talk about that because that really will affect me directly. You're going to add a few parking spots to the back and say they're staff only. Well, are you going to have a full-time security guard monitoring that? Because no, that's not what's going to happen. If you said 75% of the current clientele of the current fitness club, they don't travel by car, that means 25%. We're talking 7,500 square feet of essentially a social meeting space. We're going to have traffic back there. It will become a bit of a party alley. It'll go late into the evening. And I have to comment on the little green space that's just, was just uploaded and added. That's going to create a little non-city park at the back. Now let's think about that. Will that be utilized by other members of the community? Is that going to be monitored, fenced in, have security in and out? I'm sorry. No, you're essentially putting a public park which will have litter and maintenance issues right at the back of my house and the house of my neighbors. So the customer parking, we talked about that. The impact also in front of the property, there is almost no parking on Dundas Street there, and there's a TTC stop. And we have a long-term care facility that abuts to the back of this. We have community housing right across the street, and of course the park, and schools, and the community centers, etc. So I don't see how a 7,500 square foot fitness club, and this is the slippery slope into future commercialized use like a restaurant or whatever, I don't see how they're going to manage the deliveries in and out, cars, taxis, dropping off, picking up, right in the middle of a TTC stop that services some of our more at-risk community members, those who utilize the park, those who are in community living, and of course the elders and seniors, very important at the Maynard Nursing Home, to which I live next door. And we already have in this community an enormous impact by having those institutions here because they need to deliver things. So we really want to look at this through the lens of adding to the neighborhood, as many other people have said on these other files, rather than taking from it. It's a beautiful building. And we need more sort of, businesses to come in like Geary Street, where small, non-disruptive, non-food-based industries can operate in our city. And if that doesn't continue to happen in our city is doomed in many ways. Lastly,
Mr. Whipple, Mr. Whipple, your time is up. Could you wrap up, please?
I will, and I just wanted I had submitted in my materials just a current example of how the developer has treated the laneway. I'm the guy out there collecting garbage from our street and on our laneway every day, every other day. There's been dumping at the back there that I've contacted the real estate agent, contacted the city. That stuff has been there for a year. Garbage dumped back there, and that's when there's no.
So, Mr. Whipple, those are not matters with which we can deal. There are other departments in the city that will deal with that.
And I understand that. I'm simply saying, if that's an indicator of this developer's care and involvement in this neighborhood, that's unfortunate. So, I don't mean to sound negative about any particular, about the idea of redeveloping that building. Lovely. But let's do something that fits in with the neighborhood, with residential and high-needs residential institutions all the way around it. Thank you very much for your time. I appreciate you calling time on me. Also appreciate the opportunity to talk this afternoon. Thanks very much.
All right. Panel, any questions of this witness? All right. Is Mr. Lawley? Have we found Mr. Lawley?
This recording. Press 2 to listen to it. Press 3.
I tried to call him. This is what. Just give me 1 second. I'll give him another call.
But you're getting
Press 1 to accept this recording. Press.
Hi, yes. Sorry, I just had some voice issues. So I live in 1097,
could you just give us, sir, for the record, could we have your name?
Yeah, it's Patrick Lally is my name.
All right, thank you. Go ahead.
Yeah, so just to reiterate what Bill said, I think it's a great idea, but just the location, like I would be very aware of the back where we lived on the Halton Street, just the parking, you know, and if the patrons are going to be 25% are going to be using the vehicle, I just think that the location is not suited for this application. So that's it for me. Thank you.
All right, thank you, sir. Mr. Cronus?
Yes, thank you, Mr. Chair, members of the committee. Just a couple of points. I don't accept the label, it's a social meeting place. It's a fitness club, fitness center. Of course, people know each other, but it's not a gathering like an auditorium. It's not like a major sporting event. So I think if you approach it from the label of a social meeting place, you come up with a different set of conclusions. If you approach it strictly on the definitions found in the city's bylaw of a fitness center, it's intended to allow people to come, do their workout. Typically, anywhere between 6 and 7 in the morning is the peak times. They close at 10. There's no windows on this facility on the east side, so there's no possibility of noise emitting. It is a vacant site right now. We've had challenges with people using it illegally for parking. The repurposing and reuse and the cleanup of the building, the graffiti, will certainly blend this building back into its original character in the area. As I said, the fitness club's been in the community, not just next door, but within the broad community, close by, less than 600 meters away, for the last 10 years. And you have some letters of support that indicate that they're a great contributor to the community. There is no food delivery, there is no food service on the site, so there is no need for deliveries. The issue of the park, it's a conundrum. You try to satisfy planning's concerns. They want to revive the area and make a contribution. By doing so, you're criticized for creating a little non-city park and loitering and meeting. Like, it's difficult to satisfy everyone's concern. We understand where they're coming from, but the fact that you have a very established operator, the fact that you have a committed operator that is just transferring his business from a location that's nearby to here, I think is an asset to the community, and it will continue to contribute in a positive manner. The parking spaces are a necessity because the bylaw says so. You know, if we can eliminate it, but you still have a vacant site that has these traditional issues. We think the provision of the parking for staff and the knowledge of our experience with the operation of the facility, there's not going to be any issues with parking. We provided ample maneuverability for the vehicles, a little sodded area basically that's going to beautify the location and allow for some penetration of groundwater into things. Everyone loves it, but it's one of the, what I said earlier, you satisfy one concern and you're faced with another concern. So I'm in your hands. I hope you find it fair with the application. And you can see in the site plan we put some bike parking facilities. Hopefully they're the ones that become used and all the parking spaces remain empty. But at least it's a much better improvement from what's currently exists, and we agree that it needs attention in the manner suggested by the planning department.
Mr. Cronus, is the building next door the Portugal Festival, or the Festival of Portugal, or something like that?
To the immediate east, sir?
To the west?
To the west.
I believe.
I believe it is. I believe it is. I was trying to Google it at the same time. I believe it is, sir.
Yeah. Do they hold events, social events on their building?
I imagine they do, but I'm not there. I'm not there every day to. But it is like a social club in a way.
So when was this? Yeah, there it is. I don't know what they do there, but I walked by there this weekend. When was it last used as an auto repair shop?
I don't know the exact answer, sir, on that one, but I've been involved in this matter now for about 3 years, 4 years, and it's been vacant for that period of time.
Yeah.
And it was for sale for a period of time before that. So it's been at least 4 years, maybe 5.
Yeah, okay. All right, panel, do you have any, Larry?
Yeah, I just wanted to confirm, a lot of the written opposition was about the rear area parking. And you had mentioned that it's going to be for staff only. Are you going to sign it as such? Is it going to be signed, like staff parking only?
Yes, we could absolutely do that, sir. Absolutely
I think
do that.
that would be a good idea. Might satisfy a little bit of the concerns about patrons parking in there occasionally. So if you sign it for staff only, that might help satisfy some of that community concern.
I agree, sir. We can absolutely do that. Signage is a very good recommendation. If you want to attach it as a condition of approval, we'd be more than willing to implement that.
Okay.
It's kind of awesome
Yes.
to have someone who's in fitness to drive to a facility where they live in the neighborhood. You know, that's part of your fitness program. Not my experience is you want something very close, especially in an urban area. If you're living out in the outskirts, like in Oakville, where you have a Good Life Fitness and a shopping center, you know, then you'll drive there. But this is intended to serve the immediate residents, and most of the membership, if not a very high majority, are in the neighborhood. They're neighbors.
Joanne?
Yep, I noted in the submissions that you were suggesting that the rear entrance is only gonna be for staff. Am I correct in having discerned that from your submissions?
Yes, you are.
The client entrance is only going to be on, Dundas?
You are correct. I think in the letter that I prepared when I filed the landscape plan in response to some of the comments I received at that particular point in time, you need to be able to control your memberships coming in and out. You want to know who's there for capacity purposes and also for COVID purposes nowadays. So you wouldn't want it to come in from the back. It's not set up for that at all. So yes, it would be just for staff. You know, again, if you want to make that somehow a condition, which we don't believe is necessary, but that would be fine. We don't have any intention of having uncontrolled entry into this facility, given the experiences of today's environment and the need to ensure the capacity, who's there for liability and other purposes.
And, just another question, I think you noted just a couple of minutes ago, the hours of operation are what, 6 a.m. to 10 p.m.? This is not a
Yes.
24-hour facility?
No,
Is that-
no, it's not. It's not. It's absolutely 6 to 10.
Thank you.
All right, any further questions or comments, or do we have a motion? Larry?
Chair, I'm happy to move a motion. I actually think this is a reasonably positive adaptive reuse of an existing facility, and certainly is a lot better, I would imagine, for the neighborhood than an auto repair shop. I'm frankly not sure whether any kind of use would satisfy everybody's concerns in the neighborhood, but it is a strategic location along Dundas Street. This seems like a reasonable use of the facility that exists already. It's already been commercial. It's not converting from residential. I think it's actually a pretty good proposal, and particularly given that it's the same owner who has come back after being refused at this committee with an alternative use, which I think is perhaps better than what was originally. So I think this is actually a really good proposal. I'm prepared to move approval subject to planning conditions. And I would like to add a condition, I don't know whether we can or not, but for signage around the rear parking lot to be for staff only.
Okay, do you second that, Jim?
Yeah, I would second it, and I just echo some of Larry's comments. You know,
in favor? Have your approval, sir. Thank you. Number 17, 77 Mayfield Avenue. Purpose of this application is to permit a swimming pool in the rear yard of the existing two-story detached dwelling. With this application, we have material submitted by the applicant, and we have a report from Urban Forestry. Mr. Rebo. Yes?
Speaking.
Sorry, through you, Mr. Chair, we also have correspondence in support from 75 Mayfield Avenue and correspondence in opposition from 73 Mayfield Avenue.
Yes. Thank you. Mr. Rebo?
Yes, hello. Good morning, or afternoon now.
Yes.
My name is Matthew Revo from Perspective Views. I'm the agent representing the owner, Scott White, of 77 Mayfield Avenue.
What's your address, sir?
Sorry, my address is 126 Catherine Street North, Hamilton.
Okay. I don't think we need a presentation from you, panel. Do you have any questions of Mr. Rebo? Yes, Joanne?
Yes, I'd just like to hear some comments with respect to the submission from number 73 and whether or not there's any opportunity for any mitigation measures to be taken with respect to the concerns expressed in that letter.
So, just to summarize the letter, the main concern would be noise.
Yes.
And my understanding, well, a couple points that I'd like to make. We did check with the manufacturer, and the noise level, the decibel reading from the manufacturer is 45 decibels, and that is in compliant with the city's required noise bylaw. I'd also like to point out that that same neighbor happens to have an air conditioner unit, Mitsubishi model number R22, that actually runs at 52 decibels. So I found that interesting, that she's complaining about noise from a pump that is really within reason, and when she has equipment herself that is non-compliant.
So
Also, I could add to that, the neighbors directly beside Mr. White have never complained about noise from him or his family or any other occupants in the house. It seems to be only this one particular neighbor residing at 73 Mayfield, and it has been known that she's complained, with almost every application. Sorry, I can't say that. It's known that she's complained on other applications. She has been a nuisance with past development projects.
Mr. Rebo, I take it from that letter that this is an existing swimming pool?
Yes, so I'd like to clarify that as well. So we submitted photos as well, part of the application. This is really a glorified hot tub, and I'd like to dive into that a little bit more. So the owner installed this hot tub under the assumption that this would be considered spa. Now, under the bylaw, chapters 447 fences, there are exemptions under section F2, where whirlpools, hot tubs, and spas are not required to do a fence enclosure if a lockable lid has been provided. And so again, this is called a swim spa. It's basically a treadmill for swimmers. It's got a motor that runs a little bit of a current so that you can actually train swimming. You can swim in one spot of the spa unit, and it also doubles as a hot tub. So the owner installed this under the pretense that this was a hot tub and therefore didn't require an enclosure. However, we've forth with municipal staff trying to get clarity on this because whirlpool, hot tub, and spas are not defined terms in the building, in the bylaw. However, swimming pools are. Now, up until to date, no municipal staff has gotten back to us verifying this issue or willing to provide definitions for whirlpool, hot tubs, or spas. Again, why one person would be able to have a hot tub and the next not. And so, sorry, I lost my train of thought on the question, but basically we're trying to explain that this is essentially, this should be considered hot tub or a spa and not a swimming pool. Now, we are here today only because we've been going back and forth since the original notice that was issued to the owner on October 30th, 2019. And we've tried to work with municipal staff in resolving the issue and the matter. But again, we haven't got much direction other than eventually the chief building inspector directing us to go for minor variance in order to rectify the situation. But he agreed that there should be no issue in obtaining municipal staff support. But we have not been able to get any more feedback from municipal staff in this matter because I think most people are just unsure on how to respond with the situation.
Okay, so, but it is there already, and usually when we have an existing structure that hasn't received approval, it says to legalize and maintain. So.
Correct. Correct. To answer your question, yes, this was installed again by my client, the owner, Mr. White. His interpretation was that this was a spa and therefore exempt from requiring a building code.
Yeah. No, I understand that, sir.
A notice was issued, and therefore I would agree that I suppose the description should include legalizing existing site conditions.
Okay. Panel, do you have any other questions? Yes, Larry?
Chair, I was wondering, just again, another point of clarification. I noticed that there's a forestry report on file for this application, which recommends forestry condition number 4. And if you look at what that actually is, forestry is requesting a deferral. Maybe I can just ask for some clarification on that condition.
Sabrina, do you know?
Through you, Mr. Chair, that's correct. It doesn't explain the reasons for deferral. Not sure if the agent has had any conversations with Urban Forestry.
We have, again, we're trying to get any feedback from any department at the staff and have been unsuccessful. We've documented several instances where we've reached out to both the Urban Forestry as well as the zoning department. We did get a preliminary zoning review. We don't agree with some of the, again, with the fact that they're classifying this as a pool. However, we are trying to comply and rectify the issue. We can say that this this property was developed with a rear yard addition, a significant addition, and that is shortly after the pool was installed, the spa was installed. And again, we had to get approvals from Urban Forestry at that time. There was no damage to the tree. There was an arborist report completed. I have to confirm the date, but there were no issues with the tree, and we don't understand why Urban Forestry would have no issue granting approval for the development of a rear addition, and yet have issue for a hot tub that's installed on a slab at grade. So no injury to the tree has happened, and again, we haven't been able to successfully obtain any additional information from Urban Forestry to either support or reject the application.
So is there a
Through you,
previous
Mr. Chair.
documentation?
Sorry, through you, Mr. Chair. What's on the screen right now is the memo from Urban Forestry dated September 21st, 2021. And it does go through the condition if committee is to approve this application.
we can approve it, subject to the condition. Is that right?
That is what this memo is
We
stating.
don't have to defer. Okay. All right, Larry, do you have any further question?
No, just looking at this memo, was this in our package or is this some, I hadn't come across that memo?
Through you, Mr. Chair, this was not included.
Was not included,
Can someone
Larry.
just paraphrase what exactly, so what's the condition here? So they have to submit a application to injure or remove a tree, even though a tree hasn't been removed or injured?
They have to deal with forestry, I suppose.
So I'm, again, if somebody could comment, I'm not, first of all, this is the first time we are seeing this memo. And I don't see it uploaded to the interactive application online. However, again, I'm trying to understand why this would be required when we've already gone through this process for the development on the structure, the house.
Well, Mr. Rebo, it's something that forestry asked. We'll make, I mean, presumably we'll make it a condition, and you'll have to deal with forestry, as you've been doing already.
Yeah, correct. So again, if it's a required submission, then obviously we'll follow suit. I was just hoping that maybe we could get approval without that requirement.
Yeah.
Through you, Mr. Chair, again, up on the screen, staff is showing the first point regarding the location of the, what it says, proposed pool.
Again, it's a hot tub and it's been installed about 3 years ago.
And for point of clarification, the zoning examiner has determined that it is an ancillary structure containing water.
So that leaves me to a follow-up question. We're still unclear as to why, if it's considered a pool, why is it also considered an ancillary structure? And if you take a look at the photos that were submitted, again, you'll see that this is, appears, it looks like a hot tub. It's a large hot tub.
Well, sir, we can deal with the variances. You'll have to deal with forestry or any
Sure.
further issues at planning.
We'll continue to do that.
Yeah, okay. All right, panel, do we have any further questions, comments, or do we have a motion? Yes, Joanne?
Having looked at all the material that's been submitted, I mean, it does look like a swim spa, certainly larger than most hot tubs that we've seen come before us, but, you know, the definition is to the zoning examiner and just deal with the variances that are before us. The variances that are before us to deal with this, I think, are relatively minor. I think that, you know, it has been buffered with respect to the fencing. I think in context it's minor, and I would be prepared to move a motion to approve it subject to forestry condition, if my colleagues have no further comment.
All right, so I take that to be a motion. Larry, are you seconding the motion? Yes, okay. All in favor? You have your approval, sir. Thank you. Number 18. 1962 Dufferin Street. Purpose of this application is to construct a 2-story laneway suite at the rear of the existing 2-story detached dwelling. With this application, we have material submitted by the applicant, reports from planning and engineering, 9 letters in support. Mr. Rice.
It's Race. Good afternoon, Mr. Chair.
Oh, Race, sorry. Okay, can we have your address, sir?
140 Yones.
140 what?
Young Street.
Young Street, okay. I don't think we need a presentation from you. Panel, do you have any questions? Do we have any comments? Do we have a motion? Yes, Joanne?
Thank you. Taking a look at what's being proposed and the material that's been provided, I think that initially the height caused me a little bit of concern, but when you look at the plans and the grade change at the rear of the property, the heights of the floors are, the first floor is 8'9", the second floor is 8 feet, so we're not looking at extreme interior heights that are unreasonable. I would be prepared to move a motion to approve the application subject to development engineering conditions and the planning condition tying it to plans.
Thank you. Seconder? Larry? All in favor? Have your approval, Mr. Race.
Through you, Mr. Chair, we have to switch to YouTube stream as we're over time. We have to switch to YouTube stream to ensure that YouTube keeps running. So everyone listening on YouTube, we're just going to switch to the September 29th PM session. Thanks.